Hi there, Dr. McQueenie here, and I'm going to talk you through the slides that I posted this week for weeks 4 or 5. I appreciate your forbearance. I got myself a little backlog. It's some pretty important work, and so I slipped a couple of days on the assignment, and we'll be able to make it up, I think, this week and continue on from there. That's one of the reasons I want to meet with you in your groups, because I think when we do sit in groups for however long it takes, we can be discussing a wide range of things that might be on your mind from the readings and other discussions. So today all I'm going to do is I'm going to try and hit some of the high points of the book. As you know, I don't lecture over the books in any of my classes. I try to bring in a slightly different perspective or explain things from a different perspective. You have the books. The Rosenblum book is quite good. It's high level and it's general, but as public administrators, you don't need to have a level of expertise of administrative law. You have to be able to understand what it is in many cases, and you have to be able to anticipate decisions and their impact. You have to be able to position your agency, or if you're contesting the agency or working for a public interest group, you can position your allies in a way that you think you can understand the administrative law issues and how to deal with it. So I like the public administration perspective because nobody wants to be a lawyer these days. Well, the action is in making stuff happen, not challenging those who try. But I think that the way this course has been structured will give almost anybody who goes through there a much better and broader understanding of administrative regulation and how it pertains to public administration generally and to government, both state, local, and federal. First of all, let's review where we are. As I said, this is a combined week 4 and 5. The readings were posted, and I asked you to keep up with the readings in the book. Week 4 focused on the issue of rulemaking, and 5 on evidentiary adjudication and enforcement. And I'm throwing a couple of other articles this week for perspective. I'd like you to read the additional articles, but I really don't insist that you memorize them and let's say own them the way that I'd like you to own the textbook. I'd like you to use them as I intend them to and as I refer to them to, as perspectives. I have an article that talks about the substantial modifications in that are being discussed in administrative law, Administrative Procedure Act. There's an article that talks about the current state of regulations. There's a small vignette on the impact that Trump has had on regulations. It's important you know those things, and I think it's good for you to read them. But I would read the text with a view towards knowing and understanding most of the key points in the text. The supplemental articles would be to know it, understand the point, be able to refer to it, but not with the intensity that you would the text. So I don't consider the extra readings a burden, because I want you to read them as you would read most things of interest. And that's not a skim, but it's a go through the reading with interest, but not with intensity. And that's, I think, that'll be good for you to keep that in perspective, because I'm going to try and put some perspective readings in each of the weeks. So you should know them, you should know who wrote them, you should know the authors, but you should have, at best, a general idea of what they're talking about. Save the detailed understanding for the text. That's why I'll go through some of this today. Let's talk for a second about rulemaking. That's the chapter 4. It's a really important. Is it chapter 4? Hang on a second. I'm checking myself. I think it's chapter 3, right? Excuse me for not having this thing memorized. Yeah, it is chapter 3. Chapter 3 in Rosenblum is administrative rulemaking. This is probably the most, what's the word I want to use? The most common experience that people have with regulation in this country, because when rules are being proposed and rules are being made, they involve a wide range of citizens and businesses and government agencies and lots of discussions about the idea of the rule, where the rule came from, why we have to have the rule, and to go through and invites us to go through a process set forth in the Administrative Procedure Act, which kind of gives us a step-by-step guide on how rules are supposed to be promulgated in a democratic society where we have a legislature and an executive branch sort of sharing overall government power. You can imagine, the Administrative Procedure Act, the APA as it's commonly known, was enacted in 1946. And that seems like a long time ago, but from the issue of administrative law, it's been about 50 years or so, given the history of the country. Prior to that, there was no entity to coordinate the vast differences in understanding of administrative law or regulation, or how to implement them, or how to oversee them, or even how to fairly and justly make decisions concerning compliance or lack of compliance. uh, the country didn't really go big into regulations, as I said before, until the turn of the century, when the issues having to do with business control over all facets of life and their business power, uh, triggered that notion of arbitrary, unaccountable power. That's always been a key to reform in this country. When power, either governmental power or business power, gets to the point that the actions routinely seem arbitrary. People say, "Why is this happening?" Because they can. Why are they charging these fees? Why are they making you stand in long lines? Why do you have to fill out these forms? Why do you have to take these tests? If it makes sense, that's one thing. But when those provisions begin to seem arbitrary, it starts stoking in the American people that always has a notion for explanation, for reform, for fairness. The corollary with arbitrary is unaccountable. If power is unaccountable, if power is arbitrary, it's often unaccountable. It means someone decided he or she, as a ruler, has the right to do this or that, whatever it may be, and you can't do anything about it. I'm the president, and I can't be touched. The president is the law, and we know where that comes from. We know what that looks like. When that happens, it strikes a very strong chord in the American population, because it's contrary to the one thing that we tend to agree on, and that was the purpose of the Constitution and its findings. So when the society began reforming itself in the early 20th century and began enacting a lot of laws that dealt with government's role in agriculture, government's role in transportation, government's role in commerce, government's role in labor, government's role in the economy, those laws, as I said in the first class, were required. They were results of generally enacted statutes with very general provisions. They seemed like strict, precise laws to the congressmen who voted for them, but in reality, once you got into a situation of having to implement them as an agency with a lot of expertise, instantly there were choices to make about what the law meant. I gave you the example of the Freedom of Information Act, which just simply said make records available. Very quickly it became what time, what cost, what records, who's to say, what if they don't like it, what kind of appeal. Hundreds and hundreds of questions usually follow an effort to implement a federal law. And those questions, the Congress decided it could not deal with those questions, and it began delegating legislative authority to the executive branch. That's an important concept, the delegation of legislative authority to the executive branch to actually determine what the law meant. Many people began saying in the 20s and 30s and 40s that has given the executive branch legislative power. Congress has delegated its legislative power to the executive branch, who's supposed to implement the law, and asked it to help them think through and determine what the law means. And for many, that was a gigantic problem in constitutional law, in separation of powers, and it began creating uber powerful executives. And it wasn't just uber powerful executives, is that there was very little commonality about how these various laws, and there were hundreds of them, were being implemented. At that time, because agencies were figuring out themselves what a regulation was, there was very little consistency about what constituted fairness, what constituted transparency, what rights were given to people to review their records, what rights were given to them to contest agency decisions. And regulations began to be promulgated, which controlled, preparation of food, farmlands, which controlled the economy, which controlled environmental issues, forestry, almost any facet of American life, health, safety. No matter what level the law was and what status, there's a regulation that says here's what was meant by the law. And yet, those regulations often impacted on people or businesses, and sometimes very seriously. And any kind of law, people have a right to challenge or to be told or to be heard or to appeal it. and yet almost every agency had a different set of processes, if they had processes at all, and a different set of rules, and it was causing a quilt worth of contradictory and conflicting statutes which wound up showing up in court if they ever got to court. And frankly, it was causing people to really be concerned about the whole idea of regulation, because it seemed to be something that just could not happen in a democracy the way we were set up. Hence, 1946 decided to change this with the enactment of the Administrative Procedure Act, which was supposed to provide, and it has, the framework for consistency, fairness, to sort of channel executive power to identify what are good practices, best practices, and make it so that both the government and those who would challenge the government, the special interests and business, all have the same understanding of what an administrative process looks like, what regulations or what the development of regulations should look like, how rules would be defined, how violations would be identified, if there were contests, how they would be contested, so that there was a framework of administrative process that would appeal to all parties in litigation. And that was an effort to rein in the executive branch a little bit and say, if you're going to have this delegated power, which we think we have to have now because Congress can't do it and the regulations have to happen, then we ought to give you a guideline, a framework to work with, so it's limited, it's controlled, it's fair, and it prevents an excessive reach of executive power. Now that works in theory until you get to the fundamental issue of administrative law, because it's one thing to say, let's issue a regulation and let's promulgate rules and processes to explain how to fairly implement it. But it's another thing to do that in the middle of a political environment in which the United States is constantly in the middle of political environments. So something that might make sense to most of the country might take on a special interest, might take on a campaign finance law, for example. It might take on a climate change organization. It might take on a significant business who doesn't want to deal with the issues of restricting its activities, environmental activities. It might be related to the regulation of guns, and it might be welcome in California. It might be totally objected to in Virginia, which it is. And so that intersection between a law that makes sense, is rational, and supported by the Congress, and the implementation of it, meaning how serious are the agencies in following what the law intended, how strong are the opposition to it, how does a powerful opponent able to frustrate an agency that wants to issue regulations? To what extent can an agency bull its way over a strong financial interest? Those are questions that still haven't been resolved. And the administrative process, is important to understand, is an ongoing tug-of-war between those two, in which regulations are issued, they're discussed, there's comments, they're revised, they're reformulated, they're withdrawn, they're cut, they're added. That's been the 50-year history. It's not a pretty history. It's probably worse than making sausage. But what it does, though, it does provide that framework of ideas, of rules that are the basis for the regulation, meaning there are concepts in the law that have to do with consistency and fairness and transparency, that at least we can argue about whether the provisions meet those concepts. Prior to the APA, those concepts were not at all agreed to by themselves. So we've taken a big step in saying that the executive branch, when it tries to implement regulations, must try to maintain a framework of doing it fairly. And if they maintain that framework, they're at least better off than having just war of all against all, where there's no framework at all. And at least the parties on both sides begin to argue in favor of their policy, their position, by referring to this framework of rules that are in the Administrative Procedure Act. The biggest argument that has followed regulation all the way through has been the notion of competing concerns. On one hand, it's whether or not the regulation that's being proposed is addressing the purpose of the legislation. Excuse me. I think that you saw in the chapters in Rosenblum, I think there's been a couple of examples that are pretty good. The peanut butter example, in which a few strands of rat hairs cause a significant process of identifying how many rat hairs is sufficient, how should the public be aware of it. But I think an even better one was the whitefish example at the beginning of chapter 3, in which the botulism that was discovered in 8 cans of whitefish, where there's 15 or there's over 100 million pounds were processed over a several-year period, and there was something like 15 million a year, and yet 8 examples of botulism were found because of the preparation, because of the canning process and the like, stimulated a push towards regulatory reform, which was going to see to it that the things that cause the botulism, improper food processing, the improper temperature of the fish during processing, and a mechanism by which the canning took place, they could eliminate the botulism by simply upping the stake and causing that process to be much more tight and much more regulated. To eliminate the 8 causes of botulism, which could wind up killing people, the cost and the burden and the process was substantial, and it would have caused many companies to go out of business because they couldn't put that effort in. That's the issue, is whether the needs that we're talking about are worth the cost. It gets to be difficult when you're talking about, obviously, human life and safety. I know that for a while I worked with FAA when they're trying to adjudicate the notion of whether they need to upgrade the entire air traffic control system in the country. And the issue was that American air traffic control was and still is the safest in the world. It is safe, it's rated safe at a 99.999% value, which means that in the course of a single year, 99.999% of all flights that take off are going to land safely. And that's a good record. But when you start talking about the impact on human life, that's a good record, perhaps. But it still says there's going to be some planes, 4 or 5, I believe, that will fall out of the air in the course of a year. And the only way to stop those 4 planes or to improve the record would have been, in this particular case, the imposition of an entire new generation of air traffic control equipment, an entire different approach to air traffic control, training different types of trainers with a high technical knowledge to be able to work this stuff, and the cost would have been incredibly prohibitive to get yourself to that 99.9999% security, and it caused a big political debate in the Congress. Nobody wants to say, I'm for planes falling out of the sky, but on the other hand, how much is enough? And that's really what the regulatory and rulemaking process does. It tries to accommodate the various interests so it can answer the question, how much is enough? Now, from a public administration perspective, what we want to know is, we want to know about this process. We want to know who's raising the issue. We want to know who's making the decision, on what basis. We want to know what level of enforcement is now required. To what extent are our agencies going to be required to monitor this stuff, and are they capable? And what kind of issues in administration is our agency going to experience as they try to implement this law? Who generates the rulemaking activity to begin with? Who raises these things is also a question that public administration gets into on these matters. Now, pay close attention to Rosenblum as he talks through the various APA provisions. This tape will go on forever if I go through those, but I put a slide together which basically talks about what it focuses on. In general, it's rulemaking authority that extends to matters of agency management that deal with people or property or loans or grants or benefits. Anything that has to do with a relationship between government and a person or a company or a thing that confers a benefit on somebody is subject to a regulation. The idea of rulemaking, though, is that it's because the legislation is usually pretty straightforward. Student loans are to be granted to people going to college. There's a certain kind of requirement in terms of payback. there's a certain kind of stipulation as to what the guarantee is, and there's certain restrictions on what you can and can't do with the money. The law would say that, but then we get into how does that pertain to people of certain income levels, certain college levels, certain default rates, how about credit ratings, how about repayment plans, all that stuff. That all becomes a focus of regulation. So when a law is passed, what the agency in charge of implementing it does is propose a rule that says, here's how we think this law makes sense to be executed. And they publish that rule in something called the Federal Register. And that rule is a general statement, a policy. It invites an agency opinion on what they think the policy should be. It invites interested persons to come in and discuss the matter and challenge the policy. It allows a certain kind of decision process, and then floats that decision around to the community, the business community, the government community, for a period of 60, 90 days for comment, receives the comments, and tends to come together so the agency, and this is the point, it's a rulemaking process, but it's run by the agency, can make a decision about what the rule can be. You can think of administrative law as a tool that the agency has to make the decisions that previously it was making on its own. I'll describe the process a little more in a second, but it's not a compelling judicial process. It has the force of law when it's enacted, but it's got a lot of flexibility built into it so that the participants can participate in what the rule is and how to enforce it and overcome it. The biggest problem oftentimes has not been the decision of the rule itself, but it's been the bureaucratic and costly consequences of the regulation that have caused most of the opposition. Now, I've been talking about the Federal Register for quite a bit and Administrative Procedure Act. Let's just step back a bit, and I have two slides here. I can probably bring this online from here too, that I want you to see. I've mentioned a lot the notion of the Legal Information Institute of Cornell University. It's a fascinating website. I mean, anything you need to do from now on, the rest of your time here at CSUSB, the rest of your life, whatever, I would keep this website bookmarked someplace, because it's a really good encyclopedia and handy reference for almost any kind of law. You can see it's a fairly easy to navigate website, and I put the Administrative Procedure Code right up here so you can see what it is. Administrative Procedure Act is built into the U.S. Code Title V, and once you get to Title V, you see various different kinds of headings, sections, and if you look carefully, you're going to see that the sections in the APA track our textbook pretty closely. So the textbook isn't random. It has a section, about the purpose of the law, definitions, and we're into 553, which is rulemaking, and we're going to talk about adjudications. There's ancillary matters, there's hearings and the like, and so all the things that guide the administrative process are put out in pretty good detail in the Administrative Procedure Act itself. This website you should keep it at your side and consult it a lot if you're trying to understand something that you're reading, or trying to understand a case you're looking at, or just trying to understand an issue that comes up. I don't think there's any better single source than the Cornell Institute. I've also mentioned the Federal Register. The Federal Register is that daily document that's put together that contains every piece of information that's tracking the development of regulations and other agency business. It has all kinds of, it's really a government agency newsletter. The state has them, the federal government has them, some municipalities have them. But at the federal level, which this textbook is written about, at the federal level, the Federal Register just tracks on a daily basis thousands of issues in the relatively 300 federal agencies that go on, from appointments to reorganizations, to shutdowns, to expansions, to opening new offices, to new regulations. It is the newsletter that tracks everything that needs to be put out for public awareness or public comment. And so it's quite a big document. There is a website that I would also recommend, and I'll show it to you in a second, that is called the Federal Register. It is the Federal Register website, and it actually contains all these things now in a much more readable form. It used to be a little booklet about this big, but we published every single day, and they were very bright people in a lot of law firms and businesses that had to spend the first part of their day just narrowing through this very small print to find something that would be of relevance to their company, their business, their state government or whatnot, so they can be prepared for and participate in any kind of hearings or testimony that was taking place. I did pull these up here. Let me show you a little bit if I can on a live website. I think you get this. I hope you can. I'm not sure. I have to move my head out of the way probably. But if we look at, let's look at the Federal Register first, because take a look at the current issue. It's all nice and easy to go to now. It used to be quite a drill. You had to become a Federal Register expert, and everybody had one. But the web has made it easy. If I go to a current issue of the Federal Register, you can see that it's organized pretty well by agencies. Agency for International Development, Healthcare Research, Agriculture Department, Marketing, Agriculture Department, and in each one of these things, there are various things that are going on in the agency, and you can click to see what's going on. Here's the Air Force is doing something here. You can quickly go to a document that they're referring to, and you can see the document itself. This is submission for OMB review and comment, and it's out there with the details. It tells you if there's going to be a hearing, what day it's going to be, and how it's going to be, and it invites the public to participate. It has references up there to make it easier for you to figure out. And let me see what this is, page. Yeah, here's a PDF of the Federal Register. Now, this was the document I'm talking to you about. This was page 5,928, already in February 3rd, 2020. And you can see that the document itself is just crammed with information about agencies, about rules, about laws. Here's when it talks about the Farm Service Agency, title of a laws, application for payment, the OMB circular control number is listed, the summary of the collection process, and it goes on. And that might be not an awful lot for you at this point, unless you're in that field. But for people who are involved in that issue, whether it's a business or it's an individual trying to get a license, or it's the government agency or a state agency, this is lifeblood for them because they're usually changing a rule, and the consequences of the change in rule are usually dollars and cents for the party. Here's what an international trade system, timeline for enforcing a certain kind of regulation law, and so this kind of goes on. This is just in the A's. This is one page, but I wanted you to get a feel for the complexity of the document. And I don't know that we're going to have to spend too much time in that now, but when someone says that the APA required a posting in the Federal Register, and what it typically requires is a posting of what the new regulation might be, what the hearing date is going to be, what the time frame for comments are going to be, who they should send them to, if there's going to be a debate, who's at issue, what the issues might be, and then parties are entitled to actually submit comments, and those comments are going to be in the Federal Register itself. This is all part of the process of rulemaking, and the Federal Register remains the entity that facilitates all the information that has to come together to make an effective rule. That information is usually directed by the agency who's in charge of the regulatory issue and the administrative law judge in that agency who's in charge of that process. But all the agencies do that, and they use the Federal Register as their vehicle of communicating with the public and the interested parties. The other thing I wanted to show you again was the wonderful website for the Legal Information Institute, because it does a really good job of providing information on the law and the statute. It has copies of the Constitution, it has Supreme Court decisions, the U.S. Code, federal rules. It gives you all kinds of other information about lawyers, other research areas, and the like. But I usually stay into this get the law period, because this is where I usually live. And when you go to get the law, you can quickly identify the U.S. Code. This is out of the United States Code. The U.S. Code is the books. After a law is passed, it's put into the U.S. Code in one of several titles, chapters. And Title 5, I can probably go back here and show you the various titles of the U.S. Code. Let's see, here we go. There's the U.S. Code table of contents. And the U.S. Code is basically every law library in the country has one. Most law firms have it. This is the official booklet that contains the laws of the United States by topic. And so Title 5 deals with government organization and administration. Title 28 was Justice Department. I think I told you before, I spent most of my time when I was working. Almost everybody at the agencies looks for themselves in here someplace. Department of Justice opens up, and you can see U.S. attorneys, FBI is right there. This is everything you want to know about the FBI from the director's office and like that winds up in statutes. So it's this little website doesn't get much better than that. So we pulled up the Administrative Procedure Act, and I don't want to spend a lot more time on this, but I wanted to make it available for you to see it. And that's under Title V. It's United States Code deals with the agencies generally. It's the 500 series, and you're going to get into Administrative Procedure, which is in the 500s to 595s. You push that button, and you're going to get the same thing here. Click it again, and there is basically the outline of the Administrative Procedure Act. And sure enough, those are the topics that we are studying in the class. So if you want to actually get the basis of the material itself, go to the APA, click it. You want to read about rulemaking, we're going to talk about today, and almost everything that's in Rosenblum, the actual basis of it, is right here. So I just wanted you to be aware of that, to have it. We may do something later on in the class in one of the quizzes that allows you to play around with that a little bit, but it's an important deal for you to have. My first job in government way back when was an establishment of the Freedom of Information Act, and I was impressed because I was looking at it before I did this that the Freedom of Information Act is still one of the sections in the Administrative Procedure Act. So anyways, let me go back to where I was going. I want you to see that as a nice little break. So when we talk about the intersection of polity and politics, what do we mean? It's a nice sounding word, but it really means that with every regulation, the administrative process decision is going to be an effort to reconcile burden and benefit. There's no firm answer on what things look like. It's usually a burden on business. It's usually a burden on a section of the population, but it's usually a great benefit on the other part of the population. You know, the issue with Kobe Bryant's helicopter crash, I think, was fascinating. It's a good example here because the issue is that the regulations that perhaps would have prevented the crash were affirmatively decided not to be accepted, both by the companies and by the government. And nobody forced it. As it now appears that there were a couple of safety provisions on the Sikorsky helicopter that Bryant, unfortunately, and his friends suffered a terrible fate last Sunday. But one was a ground sensing mechanism. As the helicopter got too close to the ground, there's a warning lights and flashes and noise that usually tells it to go away. The other was the automatic instruments that allow pilots to fly on instruments when the visibility is less than I think a half a mile or something. In this case, the visibility was zero. They were socked in the helicopter. They couldn't see up or down. They had no idea how close they were to mountains, and the flight patterns had them zigzagging up and down, just trying to get away, and they really lost control, got disoriented, and crashed into the mountain, unfortunately. The issue there, though, is that everyone, this was no surprise, everyone knew that, and the county, the city, the businesses have fought every effort to require mandatory ground sensing equipment and mandatory use of instruments during times of fog. A lot of reasons why they didn't want to do that. They are expensive. If they're expensive, maybe not everybody could afford the helicopters. Maybe the companies couldn't afford to sell and use them at the price they have. The instruments, I read interestingly enough, are once you fly an instrument, you have to be part of the local air traffic control system, and that causes a different regulation of the flight pattern. And you could be in a holding pattern for a long time in a fog, flying around in circles, waiting for your time to be communicated with the control tower, and that just takes a lot of time, and it's a lot of annoyance. And most helicopter pilots do everything they can to not activate their instruments. Well, that's a choice of burden versus benefit. The LA Times has done a couple of really good things on this one. I would suggest you read it because that's a choice that regulatory law tries to deal with. Is the burden of providing the right safety equipment for helicopters, does that outweigh the benefit of that? Does that outweigh the burden of having an occasional helicopter crash and kill a lot of people and cause a lot of anguish? Those are not yes/no decisions for many people. For the consumer, it's probably yes, we should have that at all costs. But For the helicopter owners, they're not all that sure. For the companies that oversee the entire process, they're not sure. For the governments that have to deal with the bureaucracy involved in it, they're not sure. So the regulatory process, the administrative process, allows us to try to weigh these and make regulations that appear to be consensus and fair to most of the people most of the time. The whole process facilitates the discussion, this kind of discussion, and citizen participation, because the one thing we realize is that it makes no sense to have regulations that do not engage citizen participation. This is especially true in technology and technical fields where the decisions about how many rat hairs are going to go in peanut butter are something that need an awful lot of understanding, of scientific understanding. Substantial weight, though, continues to be given to business interests, which is interesting because the government does not want to slow business down or stop business down because it hasn't got any ability to deal with the ramifications of greater unemployment or lost jobs. So it tries to cajole and convince business to perhaps soften some of its stands, and it does not really have a lot of authority to force business to do something that is outside the public, the perceived public interest and business interest. A real result of this, though, is that the process is, substantial. 81,000 regulations annually are passed. 81,000. Probably get about maybe 5,000 laws, 3 to 5,000 laws that are passed in Congress, and those 3 to 5,000 yield 81,000 regulations. Those regulations are usually more intense, contain far more words, far more pages, have the force of law. So it's almost like saying that when Congress meets annually and talks about its activities for the year, it should include about 81,000 laws because every law it passes generates that amount of activity. And it puts it all in the laps of the executive branch and tells the executive branch, you figure out the most important connection between the people and the executive branch are done through this process. And so most people's connection with government is through an executive agency, not the legislature. It's been estimated, I believe this is a number out of Rosenblum, that it's costly. The 81,000 regs in recent year has the effect of costing every family an additional $15,000. It's just costs that are absorbed because of increased licenses, rules, prices of products, and the like. It has caused a gigantic leap in the federal bureaucracy. There are now 300,000 federal employees that work directly for regulatory agencies, and they basically hold, even on times of different philosophies, like the rulemaking, ebbs and flows. The political era that included usually Democrats, but certainly the Obama era, included a lot more regulations that were being made, which frustrated a lot of Republicans because they thought it's choking, constraining business. So Trump comes in and does a gigantic reduction of regulations, and he's made it a fact that no new regulation could be established unless 2 additional ones were eliminated. That was received quite well by the business community, and it's in the readings that I offered you there, and it explains the ebb and flow of this policy. But that has still not reduced the number of federal employees that are there because the workload is so substantial that you can spend a lot more time on 1 or 2 regulations and get them right as you could crashing through the voluminous number that we have out there. So the issue of how it begins is usually it's not something the government generates. I've been working in the government for 40 years off and on. I have never met a bureaucrat who wakes up in the middle of the night and says, today I'm going to invent a regulation that's going to screw all these people because I can't wait to exercise my power. It doesn't work that way. The issues usually come up in a variety of public, community type environments, business alliance, consumer groups, special interest groups, and they usually are in response to a problem like the helicopter crash or the botulism cases or problems having to do with some criminal problems that are impacting on the community. Issues having to do with significant environmental damage or significant water pollution. Any of these things that happen. Look at the regulations that have been enacted since the Flint, Michigan debacle. So there's a problem out there that a vested interest, whether it's business, consumer, scientific community, says, we really shouldn't have to endure this again. So let's see if we can either get a law passed to address it, or look at the existing laws and put out a request for tightening the rules. And that process usually then has an advocate. It's often government, but it's as often an interest group who's appealing to government, and government's doing it on their behalf to get a discussion going. So that's where it becomes more, again, of a public administration issue, again, because there's an awful lot of people who are looking at city and county and federal government to be more responsive and more effective in what they do. The issue that is different than statutory law is that regulatory law has these 7 criteria identified in Rosenblum. They're good criteria. I suggest you read them. But they are basically guidelines. They're soft. And the first one, flexibility, says it all. It's that the regulatory process is supposed to accommodate, to the extent possible, business interest and consumer interest and social interest. So that in effect we do have a collaboration of sorts coming together in some sort of a consensus policy. The Administrative Procedure Act was not supposed to jam down regulations down the throats of people, but they're supposed to engage in a process in which all sides could understand the difference, and that all sides should maintain flexible for the compromise that's likely to be worked out by the agency. There should be clear policy criteria. To the extent possible, we should stay focused on the intent of legislation and the rationality of the regulation to that, but all that requires a pretty substantial participation by everyone who has an interest. And that's where the process is probably pretty good, because it does, the Federal Register process, engage businesses, schools, state governments, citizens, people, almost anybody with a concern to come in, take a look at the issue, and if it affects you, make a presentation, submit something for the record, get involved, and make your point. At the end of the day, it's supposed to be a more efficient way of running government. The process never ends. The past 25 years, from Reagan to Clinton to Obama, all the changes in rulemaking processes were making them a little more clear, a little more efficient, a little more fair, a lot more transparent, and that's an ongoing process of improvement. The Trump reforms have taken it the other way. He wants it a little bit less clear, a little more discretion on the part of agencies to do their thing. We'll see how that winds up going. But the big change happened in the Clinton years when he signed Executive Order 12866, which required an economic analysis before issuing a new regulation. Before that, regulations could be issued because the agency decided they were good ideas. I worked at the Drug Enforcement Administration, DEA, that had the regulatory potential to put out all kinds of regulations having to do with how doctors could deal with the controlled substances and the impact of writing prescriptions and the like. And they would just basically make their rules based on citizen advocacy, interests of law enforcement, things that made sense. But starting in 1288, the rules had to be subject to a cost-benefit analysis. What's going to be the economic impact of this rule on the practice of medicine, on the doctors, on the pharmacies and the like? And that has to be a germane part of the decision. And that's done 2 things. It's caused the process to become longer, and it's caused the process to become a bit more contentious, because now we know in a regulation, if we're going to look at the helicopters, for example, before a regulation is going to be issued requiring a mandatory use of warning devices, it's going to have a dollar amount attached to it, and that dollar amount is going to be determined whether or not that dollar amount is extremely burdensome to the owners of the helicopter, or whether it's something that society should absorb. And that's been a change that has caused the process to become a little bit longer and a little bit more complicated, and probably requiring a whole bunch of new lawyers for every firm. Shortly after the Clinton years, the OMB puts out circulars. OMB, Office of Management and Budget, interprets the interpretation of the government. So the regulations are an interpretation of the law. OMB, within the Executive House, interprets the regulations, and it put out a circular A4, which required that cost-benefit analysis. It basically said that there would be these 3 things: a statement of the need for the regulation, a discussion of alternatives, and an analysis of cost and benefit behind every new regulation that is issued. Let's talk just for a second about the notion of the evidentiary administrative adjudication. The thing that's interesting about this is that the regulatory process was a important change because the rulemaking process, because rules are being made all over the place and they were inconsistent. I think that didn't even get to the issue that many people are confronted when they confront regulation, is when a rule is broken, somebody gets in trouble. There's an adjudication process, a hearing, a decision whether a crime was committed, and whether or not there should be sanctions or punishments or some kind of enforcement mechanism to do the law. I did like the Cinderella case in the textbook. I think it's a good one. I think you probably should take a look at it, the whole issue of that educational process with the Federal Trade Commission, in which they gave a pretty good example of a school that was advertising that it was doing all kinds of things for its students in terms of career development. And some of them were probably an exaggeration. There wasn't really clear that people were getting the jobs they were being promised. And it looked like, to everybody's concern, that the advertisement was stretched. People were paying a lot of money, and things weren't happening the way they were. And so people brought the issue to the Federal Trade Commission, which looks at fair practices, and with a suggestion that it be investigated and perhaps even shut down. Now, what makes this case so significant, and I'll let you read it in the text, was that there were rulings on both sides. In this case, the school won its case. It won over the government. Now, the way this works is that the Federal Trade Commission held a hearing for a hearing examiner based on a motion by someone who wanted to have the regulations looked at with the suggestion that the people at the Cinderella school were abusing their privilege. The initial hearing examiner found in favor of the case. They said the government didn't make its case for all kinds of technical reasons. Well, the nature of the administrative process is that the administrative process, administrative law judge, has not taken power or authority away from the government. No matter what goes on in the agency, at the end of the day, the agency director, the agency administrator, the agency decision process is going to make the decisions. They are informed by the hearings that take place in an administrative hearing, but they're not driven by it. So they have the ability to make the decision based on the hearing record or their own facts. In this case, the guy's name was Dixon, if I recall. He decided that the FTC, which lost the Cinderella case at the hearing examiner level, they were going to appeal it to the whole Federal Trade Commission. And Dixon, who was the head of the commissioners of the FTC, decided that he was going to hear the case himself. And he, in a Trump-like approach, heard the second case and simply decided arbitrarily on many issues about limiting witnesses, limiting testimony, limiting transparency, limiting evidence, limiting regulations, and pretty much strong-armed the Cinderella people in such a way that he found against them and set in motion a bunch of policies that FTC was going to impose a lot of sanctions on them and probably minimize their ability to continue as they were doing. But there was no ability to challenge that decision within the government because the agency was the highest authority, and the Federal Trade Commission simply said, Cinderella, you're wrong, and you don't get a right to challenge it, and you don't get a right to see my decisions, and you don't get a right to see the records, and you don't get to put your witnesses. We've looked at this case, and we said you're wrong. It was a pretty egregious case of executive oversight, kind of harkening back to the 1930s and 40s, but this fellow Dixon didn't care about that because he just thought that the Cinderella thing was a fraud, and he thought it's his responsibility to eliminate it. He probably was right on the issue, but the reason this example is so interesting to me is because the key element of the key word in the Administrative Procedure Act is the word procedures. The underlying focus of Administrative Procedure Act is to see to it that the U.S. government in all its procedures maintains the notion of due process and fairness, so that at the end of the day, all parties can say they went through a process that gave both sides substantial amount of weight and pretty much equal access to witnesses and the information and the data to be able to make their best case. So that's why freedom of information and stuff were put in the Administrative Procedure Act, because the hearing process, to the extent they have it, is supposed to be fair. This one wasn't fair, and someone convinced the Cinderella attorneys to file suit in district court in D.C., and the D.C. Circuit Court looked at the record and said for the first time, They simply overruled the process as being absolutely unfair, arbitrary, capricious. Phil Dixon was set back on his ears, and Cinderella was allowed to continue its efforts to advertise or not advertise. And it was done not on the merits of the case, but done because the government, the federal government, the FTC, was so arbitrary in its actions. So again, that's the adjudication issue. It's an entirely different process. Rulemaking there's a couple of important distinctions between rulemaking and adjudication, two parts of regulation. Rulemaking is when a Congress passes a law, and we have to put in place mechanisms to enforce the law. They're complex, they're far-reaching, and the agency who's responsible is identified usually in a statute and told to begin on putting together a law that deals with what might happen down the road, how to prevent problems, how to prescribe behavior, and the like. The adjudication side is more like a criminal proceeding. It's more like that when a violation has occurred, or when practice is being challenged, or processes are being challenged, the adjudication is looking retrospectively. Did you violate the law? Did you violate the law? As opposed to what kind of law should we have? The adjudicated process looks at the law or the regulation on the book and tries to determine whether or not it was violated. The adjudication process applies to specific parties. It was the Cinderella matter. It is issues in conflict, whereas the rulemaking function always applies to general statements of intent and public policy. It's a big difference. It's a public policy focus with rulemaking. It's a specific adjudication with specific parties on the other side of that. And finally, adjudication determines when a party has violated a specific rule rather than just providing guidance. If rulemaking provides guidance, adjudication, there's a specific rule. I have an interesting little story that I want to remind you to tell you is that there's an awful lot of flexibility that these processes have to cause violations to happen because they are talking about behavior they want to change. I'll quickly tell you that back in, I forget what year it was, but I was still working at DEA, there was a big scare about what we called illegal prescriptions. Doctors began writing in the middle of the cocaine craze a lot of prescriptions to patients, and they would charge them for it. And some doctors went into a pretty hefty business, let it be known they are just writing prescriptions to those who needed prescription drugs for all kinds of things. It became a relatively nationwide epidemic, and it got to the White House in those years. It was during the President Bush administration, and he ordered DEA, which had its own administrative process, to come up with something that was going to stop the problem, and maybe even a suggestion that we would fund, because Congress was supporting it, a whole new division of investigators to look at the issue of doctors with a fine-tooth comb. It would have cost hundreds of millions of dollars. But in reality, the dollars weren't there that year. It was a bad budget year. So DEA went into a planning session, and they brought the regulatory people in. There was one fellow who was in charge of the regulatory program. His name was Hayslip. He came up with an idea that was stunning in its creativity, but shows the flexibility of the regulatory process, because he wound up saying, we're trying to figure out how to catch these bad doctors and define what kind of law regulation we can have that's going to allow us to investigate them and cause them to stop doing what they're doing or hold them accountable when they do. But he said, if you sit back and look at our regulatory authority and look at what doctors do, they may be crooks, he said, but they're not criminals. They can't afford to go to jail or to lose their license, lose their business. It would be devastating to them. And we have the ability as a regulatory agency to pull licenses, to suspend licenses. Let's just use it. And they issued a notice to the Federal Register and a regulation that basically said that DEA has now taken the position, had to go through a hearing process, that a doctor who is found to have practiced contrary to the public interest by writing prescriptions that are not medically necessary will immediately and without appeal lose their license for a minimum of 3 years, and a second time lose their license for life. DEA had the absolute authority, it still does, to issue licenses for doctors to practice in states throughout the country. If you go into any pharmacist, you're going to see his or her DEA number on a little frame in the wall that says, this is my authority to act. And they furthermore said they were going to show her seriously by informing all the offices to look around for a case so that we can dramatize how serious we are, And sure enough, they found a case in San Francisco and Chicago within 30 days in which a doctor was accused of putting out prescriptions that weren't consistent with the public health needs. And in both cases, DEA's administrators zapped them with a letter suspending their licenses, asking them to come to Washington to appeal in an adjudication hearing. And both of them came on 2 separate days. And the hearing facts, because the regulations were so tight, were clear. They were accused of doing that. They had no effective rebuttal. And the administrative law judge and finally the DEA administrator affirmed the decision. Those 2 guys lost their licenses. I don't know what happened to them, but they weren't happy campers. But the story was printed in the AMA News and in journals, medical journals all over the place, and it spread like wildfire. And that process by itself stopped the pandemic of doctors writing illegal prescriptions. It was a gigantic use of the regulation process to send a message that was so clear it made the problem go away without any need to spend $300 million on a new workforce training it or high investigations. It was just using your noodle and using the administrative process the way it was intended to be a strong advocate for good government when it worked correctly, to not overreach, and to simply be able to prescribe laws and have the ability to adjudicate and enforce them. Criticisms, I think there's a chapter that talks about them. I would take a look at them. If I were you, the biggest criticism from a legal perspective, lawyers really, they get involved in administrative law because it's lucrative. You know, if you go to Washington, D.C., if you're not familiar with it, there's a street called K Street in Washington that goes about from the White House all the way to Virginia. It looks like Wilshire Boulevard, big, huge, fancy buildings. Every one of those are or not everyone, predominantly staffed with administrative lawyers who are either firms or special interest lawyers whose specialty is administrative law. Outside this group, you don't see too many people doing it because it's a very complex set of laws that doesn't lead itself to traditional legal analysis. You have to become a specialist in the field and a specialist in the agencies. And that's a good thing because you can make a lot of money, but it is very limiting in terms of a career. Other criticisms from the legal perspective is that they're based on a lot of internal agency rules that are not that public. So it's really hard to challenge them from a legal perspective because getting the information is harder than you would think. There's limited participation. Not everybody who's a party to the case gets to participate. That decision is made by the ALJ, Administrative Law Judge, at the beginning of a hearing. There still is some inconsistent application of the law among hearing examiners. Despite the standards and despite the efforts to fix it, you still can get 2 examiners on nuance and substance going in 2 different directions. And that plays havoc in industry because if you have a person in industry, a company, who's under one set of guidelines and another company under a different set of guidelines, and they're competitors, one side's going to have an advantage over the other. And that's a problem that they're trying to work out, but there's no real mechanism to work that one out. Excuse me, and from a legal perspective, there's very limited oversight. Congress does not get involved in this at all. Contrary, the administrative perspective is a part of agency business. It's about informed resolutions. It's about adverse action processes, and it's all about equity and compassion among the various types of people and entities that are trying to have a law that makes sense and that's inclusive. And there's various different kinds of efforts in which the Supreme Court still gets involved in this stuff, not from a punitive perspective, but oftentimes from an equity perspective. Pay some attention in the text to the notion of grid regs, because it shows what happens when we try to, when the agency tries to make the process more rational by summarizing and developing standards. And you'll see in that case that it didn't go very well at the Supreme Court level because the idea of administrative perspective is fairness and inclusion at the expense of administration. We talk in the book about procedural due process. It's an important concept. Procedural due process, it's in the 4th Amendment. Its due process is repeated throughout the Constitution. It simply means that administrative law is a function in which the overriding purpose is fairness. And that everybody involved in the administrative process must be able to say that they were given the fairness that was due to them. It was due to them. And so if they're entitled to see other documents, if they're entitled to have more time, if they're entitled to talk to an attorney, if they're entitled to deal with the agency, if they're entitled to have a second chance at the compliance, all kinds of things are part of due process. And administrative law tries to evolve so those things become embedded in the regulation itself. It takes those nice ideas of judicial fairness and tries to make them part of the administrative process and in the regulation itself. And I would take a look at that notion of caveat estoppel, because the one difference there is when courts have decided a few times that if a person or a company simply wants to stop an administrative process because the outcome that they're afraid of is actually a proper outcome, the agency has the ability and the right to do that, and courts have tended to uphold that. Again, the adjudication hearings, which take place in agencies that have administrative law judges, are interesting because they are hearings. They're not trials, they're hearings in which usually a statute, congressional provision of due process triggers it, but it's usually headed by an administrative law judge, one of the couple hundred law judges that are appointed to federal agencies, but they work for the agency. They're not independent. They're independent-minded, meaning they don't have a stake in the outcome, but they are an employee of the agency. They get paid by the agency, and they have a staff that runs the hearings. Now, they have an independent recommendation, and they oftentimes make their recommendations based on the facts of the case and the law, but that decision can almost always be overridden by the presiding officer of the agency or the CEO. In fact, it has to be enforced by them. The administrative law judge doesn't get to say, here's my decision, go implement it. The administrative law judge gets to recommend to the agency director what the decision should be, and the agency director, in most cases, complies. If it's a very difficult case, sometimes the agency director or other presiding officers will actually sit in the hearing and make the decisions for the administrative law judge. But the hearings, by and large, are recommendations with all the fairness and equity that's associated in the process to the agency head, who is supposed to give it the force of law. In most cases, they do. And that, again, is a net benefit, but it's not required. Part of it is that decisions have to be based on a standard of what we call substantial evidence, as opposed to in criminal law or civil law, the preponderance of evidence or beyond a reasonable doubt. If evidence is there and exists, the agency and the ALJ can make a decision that's just based on substantial evidence, and that, of course, opens itself up for appeal and litigation and secondary hearings. And oftentimes, that's why there's increasingly, because these hearings never seem to end, there's an appeal to something called an alternative dispute resolution. It's a pretty good section in the book Rosenblum does on that, and that's a variety of different mechanisms that have emerged over time that allow people to work out their differences rather than have to take everything to litigation. I would like you to take a look at those the articles I posted that deal with reform of the process. I'm going to probably have a question on the quiz about that. I don't want to keep going on and on because this is already much too long of a tape, and I may not even run this whole tape, but we'll see. But I think it's important to take a look at it. I've taken a line from Christopher Walker's article on reform of the APA as a conclusion, and I think it probably sums it up pretty good, why it's something that probably has to happen, because the Administrative Procedure Act, like everything else, has got a little bit creaky, needs to be modernized, hasn't been changed substantially since 1946, and it probably, if done correctly, would deal with many of the issues that cause the frustration in government today, because a lot of government frustration today is business frustration and individual frustration with things like paperwork and collection and arbitrary decisions. Things don't make sense. And to some degree, the Administrative Procedure Act could be a big help if it were amended. In the article, Walker notes that the American Bar Association made recommendations, I believe about 9 or 10 provisions. Take a look at those for added accountability and things like that. I'd like you to have some knowledge of those going forward. We will probably do something again on a quiz on them, and it would be nice if you could draw from the proposed recommendations. So look at both the ABA's recommendations and the handful that Walker has decided are relevant from his perspective. Okay, it's getting late here. I'm not sure where you are. I'll try and post this in the morning, and thank you for listening.